Your Honour, if it pleases the court, my name is Cox initial J, and I'll be appearing on behalf of the defendant, Darren Selders, a 14-year-old Torres Strait Islander charged with 9 counts of burglary and 4 counts of stealing pursuant to the Queensland Criminal Code. Your Honour, the defence submits its application under Section 130 of the Evidence Act and Section 590AA of the Queensland Criminal Code to seek that the court exercises its discretion to exclude the Crown's evidence in relation to the confession made by my client in the police vehicle shortly after the arrest and during an interview at the police station. Your Honour, it is submitted that the Crown's evidence should be excluded on 2 grounds. Firstly, because the evidence was obtained illegally in breach of many statutory requirements, thus contravening public policy. Secondly, because the substantial prejudicial weight of that evidence gravely outweighs the probative value. In dealing with the first ground, it is submitted that evidence be excluded from the trial as a result of the police officer's breach of many statutory obligations within the Police Powers and Responsibilities Act, henceforth referred to as the PPRA. Section 418 of the PPRA states that before a police officer starts to question a relevant person for an indictable offence, the police officer must inform the person of their right to speak to a friend, relative, or lawyer, and they must delay questioning to allow this to happen. Prior to the questioning, my client was not made aware of this right. Section 8 of the Child Protection Act defines a child as a person under the age of 18. My client at age 14 is therefore a child in the eyes of the law. Section 421 of the PPRA relates to the questioning of a child. This provision states that the police must allow the child to choose a support person to be present during questioning and allow the child to speak to the support person before questioning without being overheard. Now, Your Honour, the police have breached this statute by questioning my client in the police vehicle without the presence of a support person. While the defence acknowledges a support person was provided in questioning at the police station, it was not one of my client's choosing. Your Honour, whilst this section strictly applies to children, I will remind that my client is also of Torres Strait Islander descent. Therefore, applying Section 420 of the PPRA, which involves questioning Aboriginal people and Torres Strait Islanders. The police have failed to fulfil their legal obligations in providing a lawyer or legal aid representative to my client. The final issue of non-compliance from the police officers I would like to make reference to is Section 431 of the PPRA. Your Honour, my client was not made aware of his right to remain silent or speak freely. Instead, he was told to make sure he answers all the questions the police ask him. This is a clear breach of Section 431 of the PPRA. Your Honour, the case Bunning and Cross established 5 elements which assist in determining whether evidence should be excluded for public policy reasons. I will apply these elements to the case now. The many significant breaches of the PPRA by the police seem to be deliberate or at the very least reckless. The defence does recognise that the evidence is essential to the Crown's case, and therefore the cogency of that evidence must be evaluated. The evidence is not very cogent because of the way it was obtained, through many deliberate breaches of the law. Furthermore, there is little evidence to suggest that the officer's conduct was a response to pressing circumstances. And the charges my client faces are not very serious in nature. Finally, I would like to remind the court that the purpose of the PPRA is to protect people such as my client from unfairness at the hands of the police. The Crown's evidence was unlawfully obtained and therefore is a perfect example of unfair and unlawful treatment. It is on this basis that the defence asked the court to exercise its use of the Bunning and Cross discretion and rule the evidence inadmissible for public policy reasons. Moving on to the second ground of the application. Your Honour, the defence submits the evidence be excluded pursuant to the fairness discretion established in Director of Public Prosecutions and Christie. Following the cases R and Lee and R and Hasler, it was interpreted that evidence could only be excluded when the probative value of evidence is outweighed by its prejudicial effect. In this case, the evidence has a very low probative value. This is because of the many signs of gratuitous concurrence displayed by my client. Your Honour, when an Indigenous person is faced with a white person in authority, they are more likely to defer with that authority regardless of whether or not they committed the crime. This is exactly what happened with my client. At the scene of the crime, each time the officer would ask my client a question relating to the stolen goods, my client would answer looking away from the officer. Furthermore, in the police vehicle, when my client confessed to the burglaries, he mumbled and looked at his hands. And at the station, when the white social worker asked if he was okay, he grunted in response. Your Honour, these are all clear signs of gratuitous concurrence, making this admission not truly representative of a confession of guilt. This oral testimony would hold undue weight in the mind of a jury when making their decision. Consequently, the prejudicial effect would substantially outweigh the actual probative value. It is on this basis the defence submits the court exercises its discretion to exclude the evidence as a result of unfairness. In conclusion, the Crown's evidence was obtained through breaches of legislation, undermining the principles of justice and fairness upon which the law is based. In addition to this, the element of gratuitous concurrence significantly limits the reliability of the confession. These facts are, as the defence humbly submits, sufficient to justify exercising discretionary power to exclude the evidence. Thank you, Your Honour.